just what appears to be done. And your lordship, in one of the cases in Manaklal versus Dr. Premchand, it was held that test always must be whether a litigant could reasonably apprehend that bias is attributable to a member of tribunal might have operated against him in the final decision of the tribunal, in the sense that justice must not to be done, but it seems to be done, your lordship. And in the present case, your lordship,
which test of bias you are applying? Real likelihood of bias or reasonable suspicion of bias?
your lordship, there is a real likelihood of bias. Since they were the Facebook friends, your lordship, they both had access towards their personal life, your lordship.
In the facts it is given that Shirish has sent the likes and the judge has not responded. How can you say that they are friends? There is no...
Your lordship,
I hope you are using Facebook.
Indeed, your lordship. Your lordship,
Now, you see at the bottom,
Your
there are
Lord-
the likes and dislikes. Just click that button.
Your lordship,
That's the
I
answer.
would like to contend that one cannot become Facebook friend unless I send them a friend request and they accept my friend request. Your lordship, most of the people who are in access with the Facebook, they know that who are their friends in the profile. We are aware that who is my friend in my profile, your lordship. Hence,
Only that limited extent of profile knowing. That doesn't mean that they have interaction with each other so that the judge has a bias or the respondent has influence. This is all we are pointing out.
your lordship, a presumption can be withdrawn from this statement, your lordship, that if a person has access in the personal life of another person, he has chances to get influence, your lordship.
It is only your imagination.
But
It is only
there
your
are
imagination.
possibilities, your lordship.
You have to point out the proved facts from which inference can be drawn. Then you can cite the principle. First you have to point out the proved facts suggesting bias. Then you cite the principle. You are citing only the principle, but you are not pointing out the proved facts from which inference can be drawn that you are biased.
Your lordship, since the fact states that it was undisputedly he was a friend of Facebook friends, the rest completely facts are silent about the case, your lordship, in the present case. Hence, only inference can be withdrawn from the present. Your lordship, for a while, if this honorable court permits,
Merely association one is believes in Facebook doesn't mean that it influences the case. So there must be access, there must be relationship.
your lordship, as earlier contended by the council, that judicial discipline is a self-discipline. Your lordship, it is a post of high integrity, and they are not similar as executive, and they should make, even your lordship, in general practice also, judges follow a certain protocols, even in subordinate judiciary as well as in higher judiciary, your lordship, that they avoid meeting personal people directly unless and until they have a very good or family relation, your lordship. The certain practice what has been followed under the canons of under the canons of judicial ethics also, your lordship, and in different canons or in different principles what has been adopted by this honorable court in many instances. Then there are certain practice which a judge follows. In the same line, your lordship, when it comes to social networking side, it is the duty of judge that when they are accepting the friend request of general public, they should keep in mind that who are their friend, your lordship. And certainly in the present case, your lordship, the chances of bias can be withdrawn.
And your facts are not clear when they become social media friends. I am talking about. I am very restricted.
Your
Before
lordship,
the case, just immediately before the case, 10 years back, there must be a connecting link.
your lordship, as old is the case, then chances of friendship will be more good, your lordship.
This is what we are pointing out. Whole thing is on presumption.
Your lordship, if
Maybe recent, maybe connection, maybe influence, maybe bias.
your lordship, if you go to the fact sheet, your lordship, it is clear from the facts that respondent Shirish was the Facebook friend and is a Facebook friend. Means at the time of proceeding, he was the Facebook friend. And your lordship, in one general case I would like to cite, in our leading R.C. Cooper case, bank nationalization case, where a sitting judge who was holding certain shares of a bank, who was a party in that bank nationalization case. In that case, judge declared that, honorable judge declared that he is holding a certain shares, and he declared that whether he should continue with the case or not. Although it was not opposed due to the dignity of the judge, but he followed the principle of ethics and he declared in the open court.
Yeah.
Your
The
Lordship, I would-
difference is he had economical interest. Personal interest was there. Social media, there is no such interest.
Your Lordship, what kind of friendship was there?
You have very difficult task to.
Your
Okay,
Lordship,
facts they have done well.
Your Lordship, regarding
Legal term.
Your Lordship, regarding
You can
the
conclude.
Your Lordship, for the regarding second issue, I would like to cite that whether the order dated August 2014 was null and void, which was passed under Section 19 of Family Courts Act. Lordship, I have three contention. First contention is that this order has been suffered from rule of fair hearing and legal maxim nemo in propria causa judex as a debate. Then my second sub-contention is the order is a non-speaking order. And Your Lordship, my third contention is that decision of judicial authority should uphold the public confidence and impugned order suffers from non-application of mines, Your Lordship.
Are you ready? All right. We will keep aside the High Court judgment. Are you ready to argue on merits and defend or oppose the trial court order? Are you ready?
Your Lordship, since the only evidence available regarding the only evidence appreciated, Your Lordship, some of the part will be done by me, and regarding the issue is mainly revolving around mental cruelty, that will be done by my co-counsel in the third issue. Hence, Your Lordship, I would like to conclude that regarding reasons for reasonable bias, that it was held in Agricultural Produce Market Committee that it is the duty of court by giving reasonable decisions to inform the litigant for the reasons for the decision, to demonstrate fairness and correctness of the decision, to exclude arbitrariness and bias, and to enable appellate court to pronounce the correctness of decision, Your Lordship. In Your Lordship, it is humbly submitted that while giving decision, judiciary should uphold the public confidence. Your Lordship, it should appear from the mind of a layman that a justice was done in a particular case. And since this is lagging in the present order which was passed by the Honorable High Court, Your Lordship. And in Your Lordship, in MC Mehta vs. Union of India, AIR 1999 SC 2583, it was held that once the principle of natural justice is violated, courts are bound to strike down the order, and there was no discretion to refuse relief or other prejudice need to be proved, Your Lordship. Hence, Your Lordship, in the second issue, I would like to contend that the order is null, order passed by High Court is null and void, Your Lordship. And regarding first issue, Your Lordship, the last contention of the council is that the issue involves issues related to the national importance, Your Lordship, and there are chances of likelihood of future coming cases. Today there is a one cases. Tomorrow there can be more cases, Your Lordship. Hence, it is very much humbly submitted that certain guidelines should be framed so that such questions and such lacunas or loopholes should not come in the future instances, Your Lordship. And Your Lordship, in many cases like D.K. Basu versus Union of State of Bengal, Vishakha versus State of Rajasthan, in Delhi Judicial Service Association versus State of Gujarat, this Honorable Court has laid down the guidelines while following the international conventions, international principles, and they have set the guidelines where there was a loophole between the laws, since the constitution does not provide regarding the conduct of judiciary, Your Lordship. But the contention is that in the recently in Indian Defense Ministry has barred people who belong to Army, Navy and Air Force. They cannot use the Facebook site since there is a question of security, Your Lordship. Same in that way, I would like to conclude that here there is a question of integrity and propriety, Your Lordship. And Your Lordship, to maintain the dignity of this office, it is essential that there should be a certain strict guidelines regarding uses of Facebook, and there should be a strict control over the uses of Facebook, Your Lordship, or similar networking sites, Your Lordship. Hence, to meet the social need, as stated in the JAVALI versus State of Haryana, the restrictions can be imposed to meet the social needs. And as per the Article 142 and 145 of the Constitution, to do the complete justice, it is humbly concluded that judges do not have right to use the Facebook, or if this honorable court under their discretion allows, then a strict guidelines need to be formed in this case, Your Lordship. If Your Lordship is convinced with the first two issues, I would like to send my co-counsel for the remaining third and fourth issue. Much obliged, Your Lordship.
Your Lordship, I, the co-counsel, would be dealing with the third and the fourth issue in the instant case. Your Lordship, the third issue in the instant case is whether chatting on Facebook by Meera constituted mental cruelty under Section 13(1)(IA) of the Hindu Marriage Act 1955 for the dissolution of marriage. Your Lordship, I would like to humbly submit before this honorable court that the provisions relating to mental cruelty, that is the definition of mental cruelty, has not been specifically provided in any of the provisions of the Hindu Marriage Act. Therefore, Your Lordship, in order to construe the meaning of the term mental cruelty, the various judgments of the honorable courts of our country and the facts and circumstances of the case have to be taken into consideration, Your Lordship. Your Lordship, I would like to cite the case of Bhagat versus Bhagat, in which it was held that the conduct which inflicts upon the other party such mental pain and suffering as it would make it impossible for the other party to live with each other would cause mental cruelty, Your Lordship. Your Lordship, but I would like to humbly contend that in the instant case where the petitioner Meera has been put on the allegation that she was a persistent user of the online social networking site Facebook, Your Lordship, this particular conduct of the petitioner is not so grave in order to call it mental cruelty, Your Lordship. Your Lordship, I would also like to contend that as we all know that Facebook has become an intrinsic part of our society and it is omnipresent, Your Lordship. Everyone in the world are well versed with the usage of Facebook and its implications, Your Lordship. Therefore, Your Lordship, in order to call a conduct that is the usage of Facebook, it cannot be construed to cause mental cruelty.
It is not only making persistent use, torturing the other person, ignoring the marital obligations, isolating the husband.
Your Lordship, I would like to humbly contend that the conduct of the petitioner is something which can cause trivial irritations or it can cause unhappiness or emotional upset, Your Lordship.
Now if you are the entire day on Facebook, what happens?
Your Lordship, I would like to humbly contend that Facebook is not something which has become very cumbersome and which requires to be accessed only when there is a personal computer lying in front of you. It is almost on our hands.
It is available, on
Indeed,
iPad
Your
it is available, but we are constantly, you must do something.
Your
It
Lordship,
will not do automatically.
Your
You must
Lordship,
use it. So you are spending your more time than attending the wife's duties or obligations to her husband.
Your Lordship, usage of Facebook can be done simultaneously along with carrying out their matrimonial obligations as well, Your Lordship. Your Lordship, Facebook is something which can be done with the usage of one hand, Your Lordship. It just requires typing and sending messages. Even the other obligations
You have to apply your
can...
mind, no? When you are using Facebook, you have to apply your mind. And you are ignoring your husband all the time and focusing on...
So you
only
consider
job.
that chatting on Facebook is more important than attending the your obligation, marital obligation?
Certainly not, Your Lordship.
Then
Certainly not. The contention
why
of...
you give so much importance for that?
The contention of the council is that, Your Lordship, that in order to constitute something as a mental cruelty, it has to be a cumulative charge and not an isolated act alone, Your Lordship.
Naturally, if you are out of 24 hours, say 12 hours are lost in sleep, remaining 12 hours, 8 hours you are on Facebook. Husband comes home, tired, and he says, where is my tea? You will say, wait, I am on Facebook. I am chatting with my friends. What you should do? Is it not a cruelty? Day after day it repeats.
Your Lordship, with all due respect, the facts are silent as to this regard that the petitioner has forgotten to perform her marital obligations. She is not denying the fact that...
This is what is the argument before the was persistent user and ignoring me. Now, as your co-counsel was saying, we have to presume something. We are assuming, because you are a persistent user.
Your Lordship, I would like to humbly contend that
You are wedded to technology.
Your Lordship, I would like to humbly
And now they are husband.
Your Lordship, the contention is that the usage of Facebook by the petitioner is not being denied by the petitioner herself.
Paramount consideration in life, whether your husband or the Facebook.
Your Lordship, but this particular conduct of the petitioner is subject to correction, and the contention of the petitioner is that if this has caused trivial irritations and this has caused the respondent upset because of the conduct of the petitioner, that could have been sorted amicably by the ways of discussions, Your Lordship, and resorting to the final remedy and going to the extent of getting a divorce from the family court was not the solution. Your Lordship,
If that was the case, did you made any efforts of consultation with
Yeah.
the trial court?
Your Lordship, facts are silent in this regard, but Your Lordship, I would like to cite the case of K. Srinivas Rao versus D.A. Deepa, AIR 2013, SC 2167. Your Lordship, in this particular case, in paragraph 31, it was held by the apex court, it was held by the honorable court itself, that in matrimonial disputes, there is hardly any case where one spouse is entirely at fault, Your Lordship. Your Lordship, when the allegation is being put on the petitioner, Meera, then the conduct of the respondent has also to be taken into consideration. Your Lordship, even the respondent had been going to frequent excursions and had been denying the matrimonial obligations, Your Lordship.
To get a peace.
Your,
If you are all the way on Facebook, what should that poor fellow should do? Go.
He shall have to go out.
Your Lordship, but I would like to humbly contend that even though the petitioner is not denying the fact that she was persistently on Facebook, but she was being at home and she was carrying out her matrimonial obligations. But going on excursions and staying away from home is not an excuse, Your Lordship, and both the acts are in proportion to each other. Thus, in our society, when the marital norms are taken into consideration, marriage is an institution which is considered as a sacrament, which is considered sacred. And Your Lordship, if the
That
apex...
is the case. That very principle applies to your client also.
Indeed, Your Lordship, that is the council contends that the conduct is subject to correction and divorce should not be granted on this petty ground, as we should also give importance to the fact that there is a small child of the parties whose welfare has to be given paramount importance, Your Lordship. Your Lordship, I would like to cite the case of Lakshmikant Pandey versus Union of India, where it was held that every child has a right to be loved and to grow up in an atmosphere of love and affection and moral and material security. And Your Lordship, we all know that the welfare of the child and getting love and affection is only possible when a child is brought up in a family. And if divorce is granted to the parties on a petty ground which can be easily corrected, Your Lordship, then granting of divorce and leading to the ultimate breakdown of the marriage would set a very bad example for the future cases which will be appearing before this honorable court, Your Lordship. So the ultimate contention is usage of Facebook, mere chatting on Facebook, to call it mental cruelty and to grant divorce on this ground would also hamper the